for joining us for this webinar on the principle of competition. And I'm really honored and glad to be joined today by three of the people that have been giving it lots of thought recently. We have Professor Roberto Caranta from the University of Turin, who has been thinking in particular about the trade-offs between competition and other goals within the directives, maybe not necessarily on the narrow scope of a principle, but more generally. So he will open up the discussion. Then we'll have Trygve Losnedal with us, who published perhaps slightly provocative paper last year saying that the principle of competition is dead, which, as you can imagine, pricked our interest. We're also very lucky to have Dagne Savokis, who has been working a lot about the interaction between competition and green requirements, or sort of more generally environmental requirements under the directives. And then, well, you know me, I'm Albert Sanchez. I've been writing about this for the last 15 years without convincing anybody. So I guess I'm going to be the sore loser in the panel. Without wasting more time, Roberto, please take it away with your general reflections on this.
Thank you a lot, Albert. Hello, everyone. It's nice to see so many good friends to have a debate. Well, a debate, that I think is important. This is science. We don't need to agree. This is not Bulgaria in the 70s. We might have different ideas. And so I will put on the table a few thoughts, but not thinking I needed to preach the only gospel and otherwise you will be burned. I hope not to be burned and then myself, but that's up to the debate. Oh, sorry about that. I will have to leave earlier than the close of the seminar because I have some teaching duties. So, well, as you can see, I'm the old bloke in the panel. And being old, I always like to start from the legal base. Why do we have the directives? And the directives are there because of the internal market. The legal base is Article 114 of the TFU. And this, of course, impacts on what the directives can achieve. And I think recital 1 of Directive 24 is very, very clear. Well, the award of contracts, procurement has to comply with the principle of the treaty. In particular, free movement of goods, establishment, blah, blah, blah. And the principles deriving therefrom, such as equal treatment, non-discrimination, mutual recognition, proportionality, and transparency. However, for public contracts above a certain value, we need procedures to ensure that those principles are given practical effort and public procurement is opened up to competition. How do I understand the competition here? And it's different from Article 18.1, where competition is, if we can say so, on its own feet. Here it is, we need to open up to cross-border competition. So that's my first point. Of course, if you read the case law, you might have uncertainties. At a certain time, they say competition. What they mean is cross-border competition, non-discrimination. At times, they are really saying competition. But you should really be very, very, very careful to check each judgment before taking it to prove anything. And this means checking them in different languages. This brings me to another point. My point, and this can be argued, is that EU public procurement is different from national public procurement. Is different because they have at least partially different objectives, and these can bring to partially different principles. But both, they are a framework within which contracting authorities can choose. They have a margin of choice, and each and every choice will change, maybe limit the competition. A very, very stupid, hopefully not contentious example. Well, down the aisle, I have printers. I guess most universities and offices, they still have printers. Until a few years ago, the universities was buying the printers. Now we are contracting a printing service. This is clearly affecting the competition, because the number and the type of companies, economic operators, ready to sell printers will be different and probably much larger than the number of companies ready to give you the printers and then provide you with the service, which means being ready if something is broken, being paid only based on the number of copies. So really wanting the printers to work. So this is narrowing of competition. Yes. Is it artificial? Well, I must say that I'm very happy that we have changed our contract, because now our printers are almost always working, and before they were not. So this means that there is this discretion and many factors playing, not just how wide is the competition. And this brings me to what Albert was probably expecting: sustainable public procurement. Of course, sustainable public procurement is changing and at times restricting the competition. But I think this is by itself totally legitimate. It's totally legitimate because Concordia Bus, our wonderful leading case, paragraphs 85, 86, clearly said that the fact that one of the criteria adopted by the contracting entity could be satisfied only by a small number of undertakings, one owned by the contracting authority, is no reason to say that this is breaching the principle of equal treatment, because besides being old, I have a background in public law. And in public law, you are taught from the first year that equal treatment, non-discrimination is between equal situations. Who decides whether a green product is the same as another product or is different and so it can be treated differently? This falls in the discretion of contracting authorities and entities. So my point is not whether you know, I think it was Woody Allen saying, God is dead, Marx is dead, and I don't feel very well. I'm not saying competition is dead. or that is not feeling well, I think competition is relevant, but is not the overriding consideration in public procurement. It is a principle. I have no problem saying it is a principle, because there is one thing I like about principle. If you have a rule and you have another rule, then only one applies. Principles are more flexible, meaning that what will be the role of the competition will be changing in the different contexts and concerning different principles or rules it is confronted with. Just to see what I think of the gun that might be aimed at me, the recent ECA report. Well, it is ultra-virus. It shouldn't be the EU worrying so much about competition per se. They should be worrying about transboundary competition in public procurement. And we know that there is very little of it around. And we all know why, starting from language differences. But thank you very much for inviting me. This is really a nice and good brainstorming. Sorry, nothing personal if I'm certain point disappearing. Sorry but sorry about that. I would really want to say until the last moment. Thank you a lot, and thank you, Albert, more than everyone.
No, thank you, Roberto. That was really good. I think it starts off with lots of things. I wasn't expecting to talk about the Court of Auditors report, but happy to do that too if people want in the Q&A. And now the next one is Trygve to tell us that the patient is not sick, but it's actually dead, or maybe he was never there to begin with. So Trygve,
thank you very much. Thank you so much for inviting me. On my screen here, it says 3 items. It's praise, article, and what does it mean? And I will start with the praise. And that's a tradition in academia to praise the others and be very humble on one's own behalf. And it often just takes a lot of time. But Albert really deserves praise. The story here is from my point of view. I write this article with very unhumble title about a contentious issue, and I'm a junior researcher in the field. And what do you expect? I expect a cold shoulder or trench wars, or but that's not what I have met. I've met Albert at conferences and others, very open, very inclusive, very curious, and just like the perfect ideal of the academic openness and curiosity. So that really deserves praise. So thank you so much for that, Albert, and for this opportunity here. Now, the second item, article. So I will give the main arguments of my article. And I have to give an excuse to the practitioners participating, because I have to start with methodical approach. I am sorry, but that is an important point of departure for my article, and why we conclude so differently also. So how do you go about methodically if you want to identify a principle of law? The normal approach is to kind of have this as law, which is a cable salad, and you really look into all of it and try to detangle it, and maybe you end up with finding that one cord, that one red cord that unites them and kind of brings a completeness and wholeness to it. And Albert did that, and that is really hard scholarly work to do that. I went for a quite different approach, much easier, much simpler, which was kind of, okay, so this is the procurement directive, and let's look at that and the main legal sources relating to this procurement directive. And you can, and the reason for my approach is that I thought like this. This is not a principle, a non-statutory principle. This is a statutory principle, or at least we have provisions on principle in the directive. So what should the methodical approach be? Well, we should interpret the provision as if it was any other provision of EU law. And that was kind of, that's the approach I take in the article. And that's why I focus on the wording, the context, the purpose to a less extent, and case law, because that is the approach the Court of Justice of the European Union takes when they interpret provisions of secondary law. And I mean, I didn't state that specifically in the article, but I mean, that is also the right methodical approach when you have principles of law in provisions of secondary law, because then you've had a deliberation among the legislator, and they have deliberated over what should be principles and not, and they have decided on including some and not including others, and they have decided on the wording, and then we should approach that provision as if it's another provision of law. And that's the methodical starting point in my article, and quite simply, wording Article 18 of the directive and Article 36 of the Utilities Directive doesn't state there is a principle of competition. It says that it's a principle of proportionality, of non-discrimination, equal treatment, but not on competition. So wording, not in favor of a general principle of competition. Competition is worded much more specific. I won't go into the details of the wording, but the main point, it's not worded principle of competition. Context, and there I look at the legislative history. One part of that history is, of course, the academic debate that has been going on for several years before the Commission came with its proposal for new directives in 2011. And then in that proposal, it wasn't proposed also general principle of competition. The wording was the design of the procurement shall not be made with the objective of artificial narrowing competition, which is a more narrow wording than general principle of competition. And that wording was even more tightened up in the legislative process. So the legal history is important context on how to interpret this provision of the directive, and also not in favor of a general principle of competition. And then you have case law. Main point there is the court has had many opportunities to say that there is a principle of competition in EU public procurement law, and we applied this to this case, or the national court must apply it to the case they need to solve, and the court hasn't done so. And then I agree on the purpose part, objective purpose argument. So I agree, competition is a purpose of some sort, objective end of the procurement directives. And I find it's an entirely valid legal argument that the principle of competition may be drawn from a objective of competition, but I don't find that it is so by necessity. And so when you have these wording, context, case law, going in the no principle direction, and you have the objective which could go in the principle direction, well, then my conclusion is the principle isn't there. The general principle of competition isn't there. If it was there, it is now dead, which is kind of the main conclusion. And do I have 1 minute more or 2 minutes?
Yeah.
Yeah, okay, because then I'll just say, which is item 3 on my list, what does it mean? What does competition mean is the question. And then I want to go back to the recital, or first question, if there is a general principle of competition, what does competition mean in that principle? Competition in the procurement context can mean different things. It can mean contest, a competitive procedure. Is it the principle of competitive procedures? And what does that entail? Is it a principle of competition understood as competitive situations, that you achieve more bids for a contract? you kind of achieve competition in the procedure for the contract. Is that the meaning of competition? And then a final meaning is that Friedrich Hayek basically aligned or says that competition can be understood as basically as market or market making process. Whatever information exchange going on in the market is that dynamic process of competition which goes on all the time. And if that's the principle of competition, what does that entail for interpretation and the content of it? And the same question could be asked for the competition objective of EU public procurement law. If one example of a potential interpretative implication is if the object of competition, of open competition in the first recital of the General Classic Procurement Directive, if that is understood in competition as Hayek, like this market-making process, I would think that is an argument to interpret the scope of the directive expansive, to give this directive application to markets or areas of the markets of the public activities that are not necessarily now undergoing the competitive process of the market. So that would be an argument in favor of expansive interpretation of scope. And there are other such examples of how we understand competition as an objective, as a principle, can influence interpretation. So that is also a point not made in the article, but in other things I've written on this issue. I'll end there. Thank you very much.
Thank you very much, Trygve. Just on the praise point, you should yourself be praised for putting yourself out there so clearly, and you're a great communicator. So if anyone has not read the 100-something pages that paper that Trygve kindly translated into English for us, then do so, because you'll see that he's very clear-headed. Whether you agree or disagree, just going through the process with him is always very enjoyable. So now I would have preferred for Dagne to go first, because of course I would like to have the last word on this, but you will not allow me. So anyway, I prepared a PowerPoint just because these days I have very bad memory, and there's a few things that I would like to say in relation to what the court has been saying. So I hope you will let me abuse my sort of position as host to present this. And basically, I thought I would explore the basic claim that I have where all of this comes from. But I guess this takes me back to the old days in Copenhagen when I was a PhD student, and somebody asked me, it's like, well, but you seem to be talking about the principle, sometimes the goal. What is the difference? And I came up with this blurb that basically, for me, the goal and the principle are very intimately related. And I think that the basic issue for me is that the principle is just the translation or the materialization of the goal. It's just the legal cloak that it takes. And I think that if you accept that we can use the expression principle to make short for a goal that is sometimes a bit more difficult to define, then I think we could be close to the same page, but not many people have bought into this. What I think is important is to look at what the court has been saying recently, which are things that both Trygve and Dagne have covered in their writing quite explicitly. And I think we all agree that it's confusing to try to know what the Court of Justice is saying, because in TIM, it spoke about a principle of prohibiting artificially narrowing competition, which is not the best way to formulate things. TIM is also interesting from Roberto's perspective in that, for example, it says that sustainability is a cardinal value. So we even have more things to play with. It's not about whether something is a goal or an aim or it's a principle. Cardinal value, we have lots of categories here that don't quite fit together. What the court does more times than anything else is to say that the obligations of the contracting authorities fundamentally have to do with equal treatment or with non-discrimination, which seeks to encourage competition. So I think there is a line of the case law to say we're trying to achieve competition, and some of the ways in which we try to achieve competition is through equal treatment and non-discrimination, and also the obligation of transparency. We see that in RAT service, we see that in Klaipedos, we see that in CONASY. But then sometimes it just goes a different way. And sometimes it talks about whether fundamental principles of procurement require that and then it just reiterates what Article 18.1 says, so that it's not artificially narrowed. So this is what I would say it's a bit of the lazy approach, to simply go back to what 18.1 explicitly says. Then sometimes, like in Comune di Lerici, which probably is the case where we disagree most in our writing, and it just goes and says actually that there's a principle of effective competition between economic operators. And it's a shame that this is already a post-Brexit, not available in English judgment, but I think Dagne and I both would translate it in the same way. So there's been at least once an explicit recognition of a principle of effective competition in procurement. And then in other cases, like in Oficina Raslog, it basically comes to say, well, you know, if you want to demonstrate you didn't have that intention to artificially narrow competition, what you need to do is market benchmarking, which effectively comes to say that we are looking at whether objectively there was equivalent to competition situation in the award of a contract. So we have lots of stuff in the case law that is not entirely clear. You know, you could pin it in different ways. But what I'm thinking increasingly, and especially after we've been having these discussions, is so what, right? So the issue is that there is a problematic labeling. I think maybe for those, you know, interested in legal cultures and so on, I think there's a certain sort of apprehension of calling something a general principle more from the Scandinavian legal culture. The Mediterraneans are quite happy to do so. But if we move beyond that, I would wonder about what are the implications of something being a principle. The traditional principles that have been recognized, and they are in the first part of Article 18.1, are usually always operationalized through prohibitions. So proportionality usually is used to say you cannot do this. And we have seen this in CONASE, for example, saying, well, what you cannot do is go beyond what the directive requires. And equal treatment is the same. We identify a situation of equal treatment through a prohibition. The contracting authority should not have been allowed, for example, to negotiate if this was an open or a restricted procedure. So whatever we call things, whatever we call them, goals, general principles, cardinal values, the way these things are operationalized are mainly through prohibitions. So I think that in competition, the problem we have is that we don't have this one or two word principle in the way it is announced in Article 18.1. It's a bit more convoluted, it's not ideal, but in the end, it's a prohibition. And the question is then whether we agree on whether this is a clear-cut prohibition or not for the contracting authorities. And I think that here, and hopefully this also moves me close to what Dagne might think, I think the issue is that I don't think it's sufficient to say we can achieve the goal of competition amongst the other goals, which rank at the same level, like Roberto was saying, through non-discrimination or through proportionality or transparency on their own, because we will always find some cases where in principle proportionate approach to something that is not clearly discriminatory and that was made transparent ends up reducing competition. And the question is whether the discretion left to the contracting authority should tolerate the less competitive situation, or whether we should have maximized the competition within that framework, right? So I'm not saying we should all be buying dirty, polluting things. That was never what I thought. It's proportionate to require things to a level. And the question is whether we have enough tools with the other principles to deal with it. I think not. I think we can reach anti-competitive, relatively proportionate, relatively non-discriminatory situations. And I think that's what the principle of competition brings. And I think there's some support in some recent opinions of Advocate General, such as Tanhef in CONASE, which says, well, if the principle is there, it's because something was tried to be achieved with it. I think it's quite clear in some areas, such as disclosure of potentially confidential information, and I think Antea Polska tells us a bit about it. So in the end, what I think is that there is a principle of competition because we need it, because we cannot simply achieve the general goals of the directives through the specific principles that have been labeled principles with a one-word or two-word short definition of the principle. And the fact that I think it's alive and kicking is that those obligations do exist. And even if the court never says, I do this because of the principle of competition, the way that lots of the rules on award criteria, on technical specifications are operationalized in the directives reflect the fact that you have to keep a minimum of competition that needs to be meaningful. So anyway, long story short, I think there is a principle of competition. I think we mostly agree that it's about ring fencing the discretion that contracting authorities are given. I think what we disagree most is about what is the mechanism to apply this discretion. And I think one of the things that hasn't come up in the debate yet is the issue about whether something is presumptively tolerated or presumptively not tolerated. I think that's where we disagree most. My proposal would be that if objectively things have been restricted, a bit what Roberto was saying, I think the contracting authority has a duty to justify it. So if we move to the printing services, it's fine. We probably have a file that says why we did that. We should have considered the impact of competition, traded it off. If this was going to cost us 10 times more, we wouldn't have done it, probably. So that should be there as a matter of good administration. And I think it's more about making those judgments sort of open to contestation. I take the point that it can create a chilling effect, which is something that Roberto has said about it. But I think that's where we disagree more. To me, I think at some point we may end up losing a bit the forest for the trees when we keep talking about whether there's a principle or not. I think for me, it's more about how much of a constraint on discretion the necessity of competition so that procurement works should create. But I'm going to stop there, and I'm going to give the floor to Dagne, which hopefully is going to bring some order to this getting unruly discussion.
Thank you very much for inviting me to participate today. So my name is Dagne Sebakis, and I work with procurement and competition law at the law firm Vinje in Stockholm. And before joining private practice full-time, I spent 5 years at Stockholm School of Economics working on my doctoral project with the title Competition and Green Public Procurement. So I'll jump straight to the principle of competition and just spill out the beans that in my view, it's clear that such a principle exists under the directive. And let me explain why. We spoke a little bit today, in particular, Trygve mentioned the context and the historical context. What I note in particular is that in every directive on procurement, ever since the first one in the 1970s, the EU legislator has emphasized effective competition as an aim of the directive. So that's clear. And it's also clear that the Court of Justice has picked up on this, not just recently, but also way back. Perhaps the most prominent example of this is the ruling in the Danish Great Belt or Stora Belt case, as we say in Sweden, where the Court of Justice, well, frankly speaking, invented the principle of equal treatment within public procurement context based on the directive's aim of competition. So you use the aim and created something that today for us is very common in procurement context. Multiple other cases of the Court of Justice have confirmed this view, that the court essentially views the competition as a name of the procurement directives. But it's also important, I think, to emphasize, and something that Roberto mentioned, is that we have sort of dual aim of the directives. So the court has used this phrasing dual aim. On the one hand side, we have the free movement, promotion of that. And on the other hand side, we have undistorted competition, whatever that means. I'll get back to my views on that later. So the fact that we now have a provision in the directive under the title, again, going to the context and sort of the interpretative tools that the Court of Justice uses. So the wording of this directive, I should say, is something that I'd like to focus on a little bit. And we do have the title above Article 18, which lists the principles. It clearly says the principles of procurement are the following. And among those principles, we see the principle stating that basically contracting authorities are not to design procurement with the intention of artificially narrowing competition. So this is the actual wording, that is the principle. To make things simple, I call that the principle of competition, whereas in real life, the principle is this prohibition of artificial narrowing down of competition. Nonetheless, given the directive's aim, in my view, it's nothing revolutionary that we do have such a principle today. Rather, it is an operationalization of the directive's competition aim. And in this sense, I really do agree with Professor Sanchez-Graells. The more recent case law that supports this view has already been mentioned. The most prominently, probably the Tim case, which did not actually concern Article 18.1, second subparagraph as such. It actually concerned the other novel principle of procurement, the principle of sustainability, so to speak. Nonetheless, in this case, the court did confirm that everything that is under the title Principles of Procurement in Article 18 is to be understood as a principle of competition. And in this sense, I find it interesting that, just to compare a little bit my views to Trygve's, that we read the same case law and nonetheless land in a bit different conclusions, although we both claim that we do the sort of regular interpretational methods of the Court of Justice. I do very much focus on the purpose part of the interpretation. So perhaps that's something that essentially leads us on in different paths. Nonetheless, besides them, there are several cases just now mentioned by Albert, where the court again mentions the principle of competition in a bit different words. Okay, so we have a principle of competition. And the next question is, what does it actually mean? Just to pick up on the last part that Albert was mentioning, what does it actually mean? And this is a very tricky question, and I think this is really where my views may differ from those of colleagues. I do fully agree that the way the principle has been phrased in the directive is really complicated. Just to have this said, what the directive says is, the design of the procurement shall not be made with the intention of artificially narrowing competition. Moreover, competition shall be considered to be artificially narrowed, where the design of a procurement is made with the intention of unduly favoring or disadvantaging certain economic operators. There's so much words there. Do we need all of these words? Perhaps we do, because this was the agreement of the EU legislator. And based on this, I understand that there is criticism towards the principle. I do understand that there are some scholars claiming that the principle simply doesn't exist because the way of writing this cannot mean a principle. And this is where I really do not align myself. I don't align myself with those views. Simply the fact that we have a very sort of burdensome way of phrasing a principle cannot, in my view, lead us to the conclusion that there is no such principle. In particular, not when we have rather clear views from the Court of Justice, and not to say the EU legislator as such, stating the opposite. So we have ended up in a situation, the way I read the law, where we do have a principle, but we don't really know what to do with it or what it means. And this is, I think, where sort of my main core point lies. Just because of this, I don't think we should be discouraged. I argue that we have tools to flesh out this principle, to fill it with meaning. And those main tools are essentially the existing body of EU law and the directive in particular, including whatever has happened in this field of law before the current directives were issued, and general EU doctrine of interpreting law and basically what principles are in EU law. So looking into sort of this way, sort of a comprehensive approach to EU public procurement law, and looking at the Court of Justice cases that have been issued by the court, including those that predate the current directive, I argue that the way I understand competition, the way I define competition, is simply having as many participants in procurement procedures as possible. In my view, the most clear phrasing of this can be found in the EVN case of 2003. But we can also see similar phrasings in, for example, the Tedeschi case of 2019. And the reason I claim this is because, based on my research, this definition of competition is simply the one that aligns itself best with the existing body of EU law. So this definition allows us to keep whatever we have and add this new or not so new principle of competition to what we already have. And further, as a next step, I'd like to also mention the doctrine of principles in EU law as such. Looking into that, we can see that we have basically two main functions that principles have, EU law principles. So firstly, principles function as interpretive guidance for other more detailed provisions of EU law. And secondly, principles may create concrete and enforceable rights and obligations. This applies regardless of whether we're talking about EU public procurement law or any other area of EU law. So arguably, given that if we agree that we have a principle of competition, arguably these two functions should also come into play when we're talking about the principle of competition. So in other words, the principle of competition ought to function as an interpretive benchmark for the directive's detailed provisions. And secondly, it should also be able to create particular rights and obligations. So in other words, be enforceable as such. Surely, when it comes to the first part, I think we can all agree that using the principle of competition as an interpretive benchmark is not so complicated, in particular, given that it's so closely aligned to the aim of competition. And then we go back to the general EU interpretive methods of looking into the purpose. When it comes to the second part of using the principle as an actual legal rule as such, one that could be enforced as such. I think this is where it really gets very tricky, and I'd like to focus on this aspect for the final part of my presentation. And here I'd like to connect it to my research on green public procurement, just also to finish up a little bit with what Roberta was initiating this seminar with. So what I found by analyzing specific provisions in the directive that allow contracting authorities to consider environmental aspects when they procure, is that nearly all of these, what I call green public procurement tools in the directive, nearly all of those contain certain competition-related requirements. So one example is, as already mentioned by Albert, was Article 67 on award criteria, which states that all award criteria must ensure the possibility of effective competition, actually regardless of whether they're green or not. And we do also have another probably most prominent example, Article 42 on technical specifications, stating that all technical specifications shall not have the effect of creating unjustified obstacles to the opening up of procurement competition. So therefore, the directive-specific GPP tools already include competition requirements within them, which I then argue make the room for the principle of competition to bring about any additional rights or obligations in the context of green public procurement. I see that as rather limited. This is, of course, not to say that the principle of competition will not have any effects for other aspects of procurement procedures. Something that pops to my mind directly in this context is the question of competition and framework agreements, given the way the phrasings in the directive on this matter have been made. And this has been, by the way, researched by others, among others, Dr. Robert Molden, who's my colleague at SSC. Another topic that sort of pops in my head without having looked into it more thoroughly is the in-house situations and the principle of competition. It remains to be seen what the principle of competition has to bring about in those situations. But to sum up, in my view, it is clear that we do have a principle of competition. However, at least for green public procurement, I argue that the aim of competition is already present in the directive-specific requirements relating to contracting authorities' possibilities to procure green. I'll stop there. Thank you so much.
Brilliant. Thank you very much, Dagne. And this is an end for the people that were watching a recording some of the time, so I'll just stop it. And then I think